Shall I go? My turn? Yeah.
Yes, thank you so much, Heidi, for reading the housekeeping remarks.
Welcome committee members, liaisons, and members of the public to the Legal Service Trust Fund Commission's Care Court Grants Committee. Thank you for joining us. We will begin at 3 o'clock. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. To use the raised hand feature by phone, dial *9 on your phone's dial pad to raise your hand, and the same to lower your hand. Please utilize this tool to virtually indicate you would like to speak in order for the chair to facilitate discussion. All Legal Service Trust Fund Commission and committee meetings will be recorded and posted to the State Bar website. As a friendly reminder that this is a video conference and to please be aware of your surroundings behind you. Zoom captioning is available. To enable, select live transcript at the bottom of your Zoom screen and then select enable auto transcription. For troubleshooting tips, for those using Zoom on a computer, when on mute, hold down the space bar will temporarily unmute you. And if you're using your phone to dial into the meeting, please be sure your computer's microphone is on mute to avoid audio feedback issues. While joining audio via computer is highly recommended. If an individual loses audio, they can call in separately using the Zoom conference number. Thank you.
All right. Thank you. Let's take roll.
All right. Commissioner Blakemore. Hi, I see you raise your hand. So there.
Here, present.
Hi, Catherine. Commissioner Campbell.
Here.
Commissioner Escobedo. I don't see Frayne, so I don't think they RSVP'd either. So they were my only person who I wasn't sure if they could come. Commissioner Iskin.
Here.
Commissioner Judge Klein.
Here.
And Commissioner Schreiber.
Here.
Thank you, everyone. We do have quorum, Chris.
Great. Okay, we only have one big main item on the agenda, but let's go ahead and approve the minutes. I'll entertain a motion to do that.
So moved.
Thanks, Art.
Second.
And was that Judge Klein who seconded?
Yes.
Thank you, Judge Klein. All right. Taking the vote, Blakemore.
Yes.
Campbell.
Yes.
Escobedo is absent. Judge Klein.
Yes.
And I'm so sorry, Eric, I just skipped over you in accident. Iskin.
Yes.
Thank you. And then Judge Klein.
Yes.
And Schreiber.
Yes.
Motion passes, Chris.
We didn't identify just State Bar staff and liaisons on the call.
Yes.
Or the conference. Do we want to do that?
Yes, good memory. I was had that on my to-do list to circle back. So I'll do a quick roll just for State Bar staff and liaisons. Beginning with liaisons, Lauren Klein from LAC.
Here.
Hi, Lauren. Thanks for joining us. Laura Brown from the Judicial Council of California.
Here.
And Melanie Snyder from the Judicial Council of California.
I don't see Melanie on there.
And then let's go.
She may not be able to make it today.
Thank you, Laura. And then for State Bar staff, Dwan Nguyen. I don't think we have Dwan. Rocio Avalos.
Here.
Hi, Rocio. Chris McConkey is here. Alexa Montalvo is, I think, attending as just a attendee, so we can bring her in if we need her. Brady Dewar. Okay. And I think that's it for our staff who might be presenting.
Okay. Any member of the public that'd like to make a comment at the outset of the meeting? Anybody identified? Hand raised?
There are no hands raised.
All right, great. Thanks, Shannon. All right, let's dig in, shall we? The meat of the meeting.
Yeah, thank you, Christian. I'll just take a moment to share my screen. Okay, just let me know if you can't see the slides. All right, so good afternoon, members of the Legal Services Trust Fund Commission, Care Court Grants Committee, LAC and Judicial Council liaisons. This is the committee's meeting to discuss and approve a request for proposals for the 2023/2024 Care Court grants. I'm going to do a very quick sort of refresher on the CARE Act, the budget bill that would become the Budget Act of 2023, just to sort of lay a foundation, who qualifies for Care Court, who can petition for someone to become a Care Court respondent. I could try to keep the background relevant to potential scoring criteria and the scoring rubric. I'll present staff's, the Office of Access and Inclusion's proposed request for proposals, which includes a grant timeline, general grant requirements, county allocations for representing respondents in each county, the scoring rubric, application topics, and reporting requirements. And then we do have a resolution at the end for the committee to approve the request for proposals as presented or as amended. Please feel free to ask questions as I go along. If I happen to miss a raised hand, feel free just to interrupt me, or someone can say, hey, Chris, so-and-so has raised their hand, because I might be looking at my other screen. So for the members of the public, for the record, and just as a refresher for the committee members, the full Legal Services Trust Fund Commission passed a resolution on March 24th of this year, creating this committee and delegating to it very specific authority. So the committee will be exercising that authority today to approve an RFP. So as a reminder, the commission created the committee and delegated, and this is starting with the second paragraph, delegated authority to the committee to approve a timeline and application for making 2023 Care Court grants, and if consistent with the Budget Act of 2023, a request for proposals, scoring rubric, and reporting requirements. And the timeline, the application topics, the the scoring rubric, and the reporting requirements are part of the RFP. The if consistent with the Budget Act of 2023 was just in case for some reason the Budget Act of 2023 did not envision competitive awards, but rather say formula awards, then an RFP would not have been necessary. But as expected, it does provide for competitive grants. So an RFP is appropriate. And then looking a little bit ahead, the full commission also delegated authority to the committee for a commissioner staff team to review the 2023 Care Court grant applications in consultation with this committee, and that this committee will make award recommendations to the full commission, and that would be at the full commission's meeting on August 10th. So I have just a couple of slides as a refresher on the CARE Act, and I'll have a slide or two on the budget bill. I tried to keep this, like I said, relevant to sort of what might become scoring criteria. So as a reminder, the Community Assistance, Recovery, and Empowerment, aka CARE Act, creates a new court program, Care Court, where adults, so not minors, with severe mental health issues can access behavioral health care, stabilization medication, housing, and other community services. Like I just pulled that language more or less from the CARE Act. The CARE Act requires that this court program launch on October 1st or by October 1st of 2023 for 7 counties that it calls Cohort 1. That's Glenn, Orange, Riverside, San Diego, San Francisco, Stanislaus, and Tuolumne counties. And by December 1, 2024 for all other counties, except Los Angeles County has volunteered to accelerate its launch of Care Court to this December 1, 2023. So LA would be going a year earlier than it otherwise would have to. Care Courts must appoint qualified legal services projects to represent those who are the subject of a Care Court petition, respondents. It provides, the Act, that the Legal Services Trust Fund Commission will fund the QLSPs to represent respondents, quote, in Care Act proceedings, matters related to care agreements and care plans. It will fund support centers to provide, quote, training, support, and coordination. And then if no QLSP has agreed to represent respondents in any particular county, the Care Court for that county will appoint the public defender's office instead to represent. the
Chris,
respondent.
Chris, do we have to select a QLSP for every county, or could we decide that no QLSP has provided a suitable application for a particular county and then basically default to the public defender?
The latter. The CARE Act itself doesn't get that detailed as to what might happen should the commission, should no QLSP apply for any particular county, or should the commission decide that no QLSP has submitted a qualifying application. But the budget bill does specify that for any county in which the Legal Services Trust Fund Commission does not award all of the funds to QLSPs, that the funds will just go to the public defender, such that the default is, should there be a county where no QLSP applies, or one or more QLSPs apply, but for some reason the commission does not make the grant that year, it can all go to the public defender. It's like the budget bill, and I might accidentally say the Budget Act, but it's still technically just the budget bill today. The budget bill and the CARE Act sort of work together to achieve that result for this year. So CARE Court respondents, and this is kind of getting at some of the potential scoring criteria, have to be adults. They must be experiencing a severe mental illness with a specified schizophrenia or other diagnosis as defined in the CARE Act. It includes excludes disorders that are due to medical conditions, for example, traumatic brain injury, autism, and dementia. Respondents can't already be stabilized in ongoing voluntary treatment. They must be, and a lot of, since this program doesn't exist yet, this court program, a lot of sort of what this looks like in practice is to be determined. I'll just kind of say that out loud. So like this next piece, they must be unlikely to survive safely in the community without supervision, and their condition is substantially deteriorating, or in need of services to prevent a relapse or deterioration that would be likely to result in grave disability or serious harm to the person or others, as defined in the CARE Act. They must be someone for whom participating in a care plan agreement would be the least restrictive alternative to ensuring their recovery and stability, and they must be likely to benefit from participating in a care plan or agreement. All of these must be true for someone to become a CARE Court respondent. Petitioners must also be adults and may generally be, and it's a rather expansive list, someone who lives with the respondent, a spouse, parent, sibling, child, grandparent, or other person in loco parentis to the respondent. It can be a hospital in which the respondent is hospitalized, a public charity. It would be I think the CARE Act specifies it would be the director of the hospital, the director of the public charity, or their designee. It identifies a particular role that would perform this function, but essentially a public charity that has in the last 30 days provided behavioral health care to the respondent, a licensed behavioral health professional who has in the last 30 days treated the respondent, a first responder as listed, as enumerated in the CARE Act, the county behavioral health agency where the respondent resides or is located. An important takeaway here is eventually, if the petition establishes a prima facie case for the respondent that the respondent qualifies to go through a CARE Act proceeding, eventually the court will relieve any of these petitioners who was not the county behavioral health agency and appoint the county behavioral health agency to be substitute petitioner for the rest of the proceeding. Okay, so that was my very brief background on the CARE Act, just as a refresher, and now I'm going to talk about the bill that would become the Budget Act of 2023. So Senate Bill 101 passed on June 15th. It was more or less the last day for the legislature to pass a budget bill. So it's still relatively recent. Pending the governor's signature, it will become the Budget Act of 2023. It's my understanding that that will likely happen by the end of this month or by July 1st. It provides the funding for the Qualified Legal Services Project, the Public Defender and Support Center services that the CARE Act describes. It provides that funding for services between October 1 of 2023 and June 30th of 2024. And so that would be for the 8 participating counties. And it actually lists all 8 of those counties that were one of the previous slides. It provides at least $20,400,000 for QLSPs and public defenders to represent respondents. The reason it says at least is because if there's any funding remaining from the Legal Services Trust Fund Commission's grants to support centers, that leftover funding for support centers will have to go to representation for care court respondents, QLSP or public defender representation for care court respondents. It provides up to $1,020,000 for support centers to provide legal training and technical assistance to implement the CARE Act. And I didn't put that in quotes, but that was a quote. Legal training, technical assistance to implement the CARE Act. And it provides $1,432,000 to cover the cost of administering these funds to QLSPs, public defenders, and support centers. That includes the state bars and Legal Services Trust Fund Commission's work to collect and report outcomes and spending data from QLSPs, public defenders, and support centers. This paragraph I briefly previewed at the full commission meeting last week. It is a little, I put it on a slide because it is a little bit different than what we normally see in the authorizing legislation for commission grants, insofar as it references collecting data from public defenders. And it also references the Judicial Council's reporting requirements under the CARE Act. So I wanted to just read it out loud. The budget bill would require the commission to collect outcome data from each county's public defender office, QLSP, and support center. The State Bar of California shall annually provide to the Judicial Council a report that includes funding allocations, annual expenditures, and program outcomes by service area and service provider. That bold language is actually very similar to what we normally see in the authorizing legislation for grants. Data shall be reported using the reporting framework developed by the Legal Services Trust Fund Commission in consultation with the Judicial Council to ensure that data reporting is consistent and comparable across Judicial Council and Legal Services Trust Fund data. Today's meeting is obviously focused on the request for proposals, which does describe at a very high level, and I do have a slide about this towards the end, what the reporting expectations are likely to be. But the Office of Access and Inclusion anticipates convening this committee for another meeting, probably in August, possibly earlier, but likely in August, to finalize reporting requirements for public defenders, QLSPs, and support centers. And again, the full commission did delegate authority to this committee to set those requirements. So I'm not anticipating a need to go back to the full commission like we will with the award recommendations to finalize the reporting requirements. So I'm going to present the proposed request for proposals unless there are any questions about the budget bill or CARE Act. Okay. I moved the timeline appears a little later in the RFP, but I did move it to the top of this presentation and the memo just because I think it offers helpful sort of guideposts for when things will be happening. So today the committee will discuss and approve a request for proposals. The State Bar will release an application for qualified legal services projects and support centers. Public defenders under the CARE Act and the budget bill do not have to apply for this funding because under the CARE Act, they receive any of the funding that's left over from the amount that was for QLSPs and PDs to provide representation. So they don't need to submit this application, but QLSPs and support centers will. That application will release at the end of this week is our goal. June 30th. I did put an asterisk there just in case there's like a technical issue or otherwise a need to release it next Monday. But the plan is to try and release it at the end of this week. Applications will be due July 17th. That's less time than we would normally like to give QLSPs and support centers, but there is a significant need for this committee to make award recommendations in time for the August 10th commission meeting, and to let counties where there are no QLSP applicants know as early as possible that no one has applied for QLSP funding in that county. So their public defender's office have a little more time to train and hire as necessary to do this work. So that it's it's going to be a slightly shorter application. Actually, I would say a meaningfully shorter application just for the fact that they only get about 17 calendar days to submit it. The commission or staff team would score applications between July 18th and 25th. Like I mentioned in my last email, We are anticipating a very small number or a relatively small number of applications this year, in part because only 8 counties are going. And I think a lot of QLSPs and support centers are sort of waiting to see what this program looks like before deciding whether or not to apply, and maybe they will apply in future years. So we are anticipating at least a couple of applications. I'm thinking no more than a handful at most. And so the scoring team likely can actually review them in such a short period of time.
What's a handful?
What's a handful? I'm going to, don't quote me on it, but I would expect 3 or 4 or fewer applications this time. I don't know for CO if you feel like if even that's too optimistic, but I don't want to say like only 2 and then we get more.
I think that aligns with our communication with grantees so far.
All QLSPs?
For the 8 counties that are for this initial cohort, or the cohort 1 plus LA County that's choosing to fast track.
One reason why staff is hedging a little bit in this estimate is we've had a great great channels of communication with the Care Court grant planning grantees, the ones that got about $14,000 to engage in a planning process this winter and spring, as to whether or not they're envisioning applying. But the some QLSPs in support centers did not apply for a planning grant. They would still be eligible to submit an application to serve 1 or more of the 8 participating counties. So there are some QLSPs and support centers we haven't really heard from. If they didn't get a planning grant, though, that is a sign that they might not be interested in applying this year, if they didn't apply for one. Okay. Staff has proposed that this committee try to meet by August 2nd, if possible, to make award recommendations for the full Legal Services Trust Fund Commission meeting on August 10th. If we can't meet by August 2, I think we're going to try to squeeze it in on August 3. August 1 would be even better. I'm still waiting for a few commissioners to let me know their availability, but essentially it'd be nice to kind of post those recommendations a few days in advance of the meeting on August 10th. Once the commission makes awards, applicants will sign grant agreements. The grant period will start by October 1st for all 8 counties, even though LA, staff's proposal for the efficient administration of these dollars is that the grant period start for all 8 counties by October 1. That is the date by which services have to start for the 7 cohort 1 counties. Those are all counties except LA. And services would start for LA on December 1st. Staff did look at whether or not to have LA, the grant period for QLSP serving LA start on December 1st, and to run a more complicated formula that would reflect a 2-month difference. But essentially, LA County is expecting half of the total number of cases for all of next year in just that county. And they're gonna like way more than any other county. And the time difference was too small to run a separate grant sort of process for them, a separate formula for them, and to do a separate grant period. So our recommendation is just to have the grant period start on October 1st. To the extent LA County has almost half the pot, they'll need that extra time to gear up.
Yeah, I was saying, and just to add that final piece, that ideally we would give cohort 1 counties a little bit more of a runway as well to prep for the grant period to start prior to that. Must be available to provide services by October 1st date. So that was another reason why we decided, we decided to propose a grant period start date of October 1st for all counties, including LA, which has a later service start date.
And you'll see on a later slide what the governor's office thinks the breakdown of cases might be for each county. You can see LA kind of has the lion's share. Okay, so grant timeline and requirements. So eligibility in the budget bill, I might at times accidentally refer to it as the Budget Act of 2023, but it would become the Budget Act of 2023. Budget bill limits eligibility to qualified legal services projects and support centers, eligibility for these grants, to current QLSPs and sports centers, staff recommends that those be current 2023 IOLTA grantees. We did look at whether or not to maybe include any brand new programs that might be getting a 2024 IOLTA grant this summer or fall. We ultimately did not recommend any potential brand new programs that the commission has never given a grant to before, but might be getting one for the first time for a couple of reasons. One is it would be a lot harder to sort of assess their ability to do this work if we are sort of seeing their application for the first time this spring, their IOLTA application for the first time. And also at the August 10th commission meeting, the commission will only be conditionally approving 2024 grantees, and that their actual approval for a 2024 award will be conditioned on their submitting acceptable budgets in the fall. So it wouldn't even be like the awards would not be final at that time. So we would be we're recommending that they be current 2023 grantees. Senate Bill 101 funds qualified legal services projects, quote, to provide legal counsel pursuant to subdivision C of section 5976 of the Welfare Institutions Code. I'll say what that is in just a second. For representation in CARE Act proceedings, matters related to care agreements and care plans. So the language CARE Act proceedings, matters related to care agreements and care plans actually tracks with the CARE Act. That's what the CARE Act describes the role of qualified legal services projects. Subdivision C of section 5976 of the Welfare Institutions Code is a very short provision that essentially says care court respondents are entitled to counsel regardless of their ability to pay. So appointed pursuant to this sort of right to counsel that's in the Welfare Institutions Code for representation in care proceedings, matters related to care agreements and plans. Given the amount available, and this is guidance that we received from the Department of Finance. Given the amount available, the 20,400,000, these grants are not to fund, and this was sort of like, it was explained to us in terms of math, are not to fund the wraparound services or support. So that would be like the actual provision of housing, stabilization medication, or behavioral health care, for example. That become part of the care agreements or plans. There's supposed to be other funding for that. And that other legal services like lobbying and what we sometimes call auxiliary legal services fall out. So auxiliary legal services might be like, we're representing them in a care proceeding, but we notice they have like an unrelated need for SSI public benefits or something like that. That sort of like we spotted something else would fall outside the scope of the budget bill because of the amount that it's allocating. I see. I happen to spot a question already. Catherine, do you want to jump in?
Thanks so much, Chris. I guess I wasn't part of the discussions, obviously, with Department of Finance, but I actually read the language of what's included within a care plan, particularly when it comes to housing, is specifically called out. And so I wonder, so you're saying, given it sounds like it's a recommendation that given the amount available, these grants are not to fund the wraparound services, which frankly are really critical to success in the program. Could it instead be that given the amount available, these grants are not required to be used for this, but may, because if you have a particular client and there's a particularly egregious housing issue and they're not going to be successful in their care plan absent that, and you had enough money to do it, why wouldn't you do it?
I think that's a great point, and I think makes sense. And I think again, this goes back to the specific proposal that the grantee or the applicant submits and how they're proposing to provide X services for X amount of clients with this within this time frame, with the proposed amount or the amount that they're requesting. So I think that goes back to looking at the proposal itself. To Chris's point, the guidance we were given is that work is very important and is likely to be part of this work, but these funds aren't meant to cover that. The calculation for these funds and the amount given for this particular cohort plus LA County
was based on an approximate amount of in-court representation specifically. So I think that gets to the guidance that we were given, not to say that, you know, if they're able to include it or if there's additional funding to cover that. I think that's something that the commissioners can take into account when looking at the specific proposal.
But I think it's important to be clear at the outset that a program could describe those services, because from many legal services programs perspective, doing that work is the quickest way to ensure a successful outcome and therefore reduction in the amount of time that you will need to spend in the care court proceedings. So if we start from the place that says you can only use this in court, you can't use it for these other services, although numbers of these services are specifically listed in the care plan and in the et cetera, all of those documents, then I think you're going to get fewer legal aid programs wanting to do the work, because it's really part of the strategy about how do you ensure that a person that is facing this proceeding gets the services and support, so the next time they show up in court, they can show that their success. So I think they're more connected rather than just saying, you know, we can say somebody, you know, like could talk about it in their application. You have a question about that, but we have to be clear that you in fact can provide those services. And, you know, if it's a funding calculation, like I think that's one thing, but I think we have to at a minimum give programs the flexibility to do that if they can appropriately do the deliverables and provide these services in addition.
Mm-hmm. Yeah, and I think that's something we can walk through when we see the RFP to see if we maybe need to add something or tweak something, or if you feel that the way it's laid out allows for the opportunity to to provide that information to the commission when it's looking.
I think I'm more concerned what would end up being in the grant agreement, and that if the grant agreement is going to include this exclusion, I think that's the problem. It's not just what's in the application.
So I have a question. I've, as many of you know, sat in mental health courts, and Catherine's correct. If you just make a finding without any accompanying services, it's meaningless. I'll put it that strong. And that's why you have these courts. But I used to have a form I just did on my own, which was a referral for wraparound. And aren't those, you know, funded by the county? And so, you know, and I know there's always a fight over what, you know, who gets the mental health funds, whatever. But that's my question. I mean, people don't pay for wraparound services.
Oh yeah, I'm sorry, Judge Klein. I wasn't saying that we would pay for the wraparound. We would help people access the wraparound services.
Well, that's a whole other.
That should be a part of what programs are allowed to do. So I'm sorry if I created.
Oh yeah, no access. I not to be dogmatic. I think that's a no-brainer.
Great. And then I see we have a few more hands raised. So I'll just before calling on the next person, I'll flag just so I don't lose it for Catherine. The grant agreements in the past, we haven't drafted the care court grant agreements yet. And so I can only speak to what we've done in the past. In the past, it usually just has language that says like, and will spend the dollars in compliance with the authorizing legislation. And then it might reference like Senate Bill 101 and the CARE Act. But it historically, it hasn't actually copied and pasted any particular restriction in the RFP into the grant agreement. So I made a note for myself that was a concern that you had about the grant agreement, so we don't forget that. But just historically, it usually doesn't pull that sort of thing from the RFP.
Now, there are other services other than wraparound. Wraparound was always sort of the Rolls Royce, and I forgot what the name of the other one was. So we shouldn't limit it. But if we're basically saying we want these the lawyers in court to request access to wraparound or other type services, which it says here, that doesn't cost anything. You know, that's a referral. Like I said, I used to have forums on the bench, and that was a little unusual, but I don't know, of course it got attention. So I don't know why we wouldn't incorporate as much as we could Catherine's comments.
Christian, I'll defer to you about order, but I think Lauren had her hand raised next.
Yeah,
then Eric.
let's do Lauren, Eric, Ephraim.
Thanks. I certainly agree with everything that Catherine said, and I wanted to first make the point with respect to the matter at hand of approving the RFP. I don't think that the language in the RFP as it is currently is clear enough on this point. I think that programs are still very confused about whether or not they can use this funding to provide ancillary services, and they're looking for a clearer answer. Whether, no matter what the decision is on what the answer is, if ancillary services are allowed or not, they don't feel like they have a clear answer. So I think we need to be as explicit as possible there, so that organizations know what they can do. And that being said, I absolutely agree that those ancillary services should be allowed. I don't think that organizations are looking to hear that they have to do those or that it's encouraged, but simply that those things aren't prohibited, that they're not going to be prevented from spending funding on those ancillary services. I think that there's a big concern that there will be situations, particularly in the first 6 months of the program, because it's new, petitions may be slow, and there may actually be enough capacity to provide a lot of ancillary services for the folks that they're representing. But if they're prohibited from doing so, organizations are a lot less interested in being involved in this program.
I thought we're talking about access. They should advocate for access to these programs. It doesn't cost anything.
Well, it's the attorney's time to do things like get someone on public benefits, do record clearance so that they can access housing, those sorts of things. That's what we're talking about. And I've spoken to HHS as recently as this morning and said explicitly, we need to know if this is allowed, if this is envisioned. And they've repeatedly told me, absolutely yes, anything that has a nexus to the care plan should be included, because the goal here is for the care court respondents to successfully complete their care plan. And if their attorney isn't allowed to do things like get them on CalFresh, advocate for them to have access to housing, then the person's not going to have success. And as the RFP stands now, organizations are not clear. I'm getting a lot of questions about whether they're going to be prohibited from providing those ancillary services to give them access to things that they need for their care plan.
I do want to jump in here just so that that was really helpful, Lauren. Thank you. But for Lauren and for the committee members, we did actually ask CalHHS, since Lauren just mentioned them, to look at this paragraph of the RFP, and we did get their approval on it. So I don't know if maybe their position is more nuanced than what we got in their approval, which might be true. But
Yeah,
we did sign off on this. I did want to ask Lauren, just this would help me respond to help guide the conversation at this really, really good point that you and Catherine are making. For some of the examples you just gave, records clearance and that sort of thing, would you mind just for a second, not to put you on like the hot seat or something, but what's your take on just looking at the quoted language from the budget bill? Like, what would be your argument for how that would be representation in care proceedings, matters related to care agreements and care plans?
I think isn't that what I sent you? Did you get what I sent you last evening?
I haven't looked at that yet. I'm so sorry.
Okay, so I did a whole here's why.
Oh, I love it. Will you do for everybody?
So it says, to support the respondent in accessing community-based services and supports is part of the care agreement. And, a care plan includes appropriate range of community-based services and supports, including housing and other supportive services. So, and then I gave you examples of what those kinds of things would be that are essential to somebody's success in accessing those, how lawyer, it's like lawyers can help you access getting in-home support services so you can have someone that assists you in taking your medication, cooking your food, whatever else you might need, or can assist you specifically, since it's called out, in maintaining your housing or securing housing, just by way of 2 examples. But, but that's consistent with the language in the statute, so that's why I'm so confused.
Having sat in courts presiding over this, we're making it complicated. You have the lawyer should have, the social work, especially in small counties, a social worker or the representative of wraparound services. They contact them, they come into court, they say if the person's eligible, they outline a care plan. And then you set appearance dates to see how it's complying. I don't like the idea of they come in next and talk about success, because mental health, it's a long process, and I got frustrated when when certain criminal prosecutors expected great progress and no situations where they fall back. But it's not the lawyers that are doing this, it's the connections they have, as Ms. Blakemore has pointed out. And this program is useless if we don't have the connection to services. I'm not being pessimistic, I'm being realistic. That's what it's all about, to get them the help, to get them the services.
I agree. And Chris, if it's helpful, another kind of concrete example that I'm hearing from programs directly is, so housing, for example, is something that counties are receiving additional funding to provide. And the way that this is supposed to work is that care respondents are supposed to be able to essentially jump a line to get access to housing. So there's huge waiting lists to get into housing. If they have a care plan, it's in their care agreement, they're supposed to be able to jump the line. What I hear from a legal aid organization is, okay, in my county, they're not saying they're going to do that. What do I do when I'm representing a respondent? They're supposed to get to jump the line. The county's not having them jump the line. Am I allowed to be their lawyer and call the county and find out what's going on? They're afraid that the answer is no.
Oh, but that's like clearly,
I'm only allowed to represent somebody in court at their care hearing, and I'm not allowed to provide those extra services to find out why they didn't jump the county line for housing, or to find out why behavioral health says they're not eligible for services, even though that's in their care agreement. Things like that. Organizations want some reassurance that they're not going to come back with their grant report and have the state bar say, no, we didn't say you could do those ancillary services.
Yeah.
Well, they used to do in my court is fine. Go tell the judge you're not going to do it. And in some cases, organizations like Regional Center do a lot of good things, but when they were denying funding, I had public counsel on speed dial, Paul Freeze, he was the lawyer. You can't do this if you're worried about in a new plan getting sanctioned by the state bar. I can't imagine the state bar would come down on someone for trying to get someone's services or housing.
Right. Yeah. And I do want to distinguish between like what the and your point's well taken, Lauren. Like the Office of Access and Inclusion kind of its role would be to check on the services and check for compliance and that sort of thing and stuff. But what's more operative to me here is what the budget bill and CARE Act say is like what the funding is for, essentially. So in our kind of good faith interpretation of essentially what's authorized versus not explicitly authorized. I do want to note that a few other people have had their hands raised, have been very patient. I just want to share that. No, Judge Klan, everything you say is very helpful. So, but I think maybe Eric was next.
No, I just point out that, and as I pointed out to you, Chris, privately, that the RFP provides that in assessing the suitability of a QLSP for funding, that when we evaluate the application, one of the things we are supposed to look at is the experience of the organization in advocating for benefits.
Yeah, no, that's a good question. I'm glad you mentioned that, because and that actually follows up on something Lauren just said. So I think maybe it is helpful to clarify this. And Rocio, jump in if this doesn't reflect your reading of the budget bill. But it's our office's reading that for representation and CARE Act proceedings, and this is the budget bill and CARE Act use this language, representation and CARE Act proceedings, matters related to care agreements and care plans, that would be funding to represent the client in the CARE Act proceeding in court, in the negotiation with the county behavioral health agency, and to help them sort of like assert their rights under the CARE Act. So if they negotiate for some services or community support as part of their care plan or agreement, and then they're not getting it, that would be included. Something like where I think it's less obvious that it's what the budget bill is proposing to fund would be like, we think if we help them solve this other legal issue, I'm trying to think of something that's like really obviously wouldn't come up in like the CARE Act proceeding, something like helping with like maybe like an immigration issue or something, that will have a sort of trickle down effect that will maybe lessen their need for something in a care agreement or plan. And that's a little less obvious to us that should be read in. But so to something Lauren said and something that Eric just said, like kind of advocating for this community services supports that the CARE Act specifically enumerates, I think that is relevant to or related, quote unquote, to care agreements and plans. Like you negotiate for them to get something and then they're not getting it. So then you're sort of asserting their right to the thing that they're supposed to be getting under the CARE Act.
Just to add briefly, because I know that we do have a number of hands up, full transparency, I think there's general agreement in terms of what it takes to make this process of these agreements successful, or how it's defined to be successful, including, you know, the conversation around wraparound and auxiliary services. But knowing that these were points of confusion for our grantees who were considering applying, those were specific points that we asked for clarification on regarding to the funding that is being allocated for this initial cohort and LA. And based on that specific guidance, we came up with a language we came up with in the RFP. So just wanted to clarify that. If there has been some confusion, we're happy to go back and further clarify. Just wanted to pass along that these were specific questions that we did follow up on to get clarity, because as Lauren mentioned, there have been a lot of questions that we ourselves have received as well in terms of whether this funding is meant to be for what purpose this funding is meant to cover, and knowing that it is limited. It did increase, but it is still relatively limited. The calculation, which Chris will go into for this funding, is specifically based on an estimate of in-court hours for in-court representation. So I think then this commission can decide how to approach and kind of like the next steps or anything that we are happy to go back and either revise in the RFP itself or get clarification, but hoping to get an approval for an RFP today. So I'll just leave it there.
And then just to make sure everyone's getting a chance to go, Efrain, I think you were next.
Thanks, Christopher, and thank you, Rocio, for that and the presentation. I won't be long. I had one clarifying question, but I think was also going to raise the point that Eric raised, which is in the actual criteria for evaluation, it does reference the Welfare and Institutions Code and sort of says you know, it will be evaluating you and your ability to actually help clients access these services. And your clarification helped on that yes, that's within it. So I guess my question to this conversation, I may have missed it, is when you say you received guidance, so was that something official? So did we receive guidance in writing that sort of says these are the bounds to the uses of the funding? Thank you for trying to ask if you could fund these additional things, but not, or is it more informal guidance through a meeting?
I'm going to see how many slides I have to advance. Okay, it's only 2. So I'll go back to the other slide in a moment, but this will help answer your question. So the guidance was not written. I want to say it was spoken in maybe 1 to 2 calls with Department of Finance, but this is essentially, and Rocio, please jump in to the extent that
I think this will be helpful.
I mischaracterized or missed something, but essentially what the guidance was the CARE Act and the budget bill. That's your written guidance as to what the grant's supposed to pay for. So representation and CARE proceedings pursuant to that provision in the Welfare and Institutions Code that says like they are entitled to counsel regardless of ability to pay, and then matters related to care agreements and plans. Like that's the written thing. What they then sort of told us was, look, $20,400,000 for qualified legal services projects and public defenders to share to serve these 8 counties. That number is tied to the following math. The governor's office is anticipating, and we've heard this might be an underestimate, is anticipating about 4,000 cases in state fiscal year 23-24. And then the third column here breaks that down. And the governor's office is anticipating that it will essentially fall according to general population. And that $20,400,000 is tied to a typical case taking about 40 hours. So at 40 hours per case, about 4,000 cases, both of which might be underestimates. you get $20,400,000 to do this representation. So to the extent, the guidance we were given, to the extent that other sort of services might become part of the mix, the CARE Act and the Budget Act might actually be like a matter related to a care and agreement or plan or something like that. And so it's like kind of like authorized. It's using a small pot of what's probably going to be a tight pot of money. So that was kind of the guidance that we got, is to like keep that in mind.
Yeah. So just for the record, my point there is, I think, so it's interesting that what you just shared to me sounds more like you could probably push and get a good clarification. Like I've been used to another grants where you request a letter of clarification and you want something in writing that says, no, you cannot use the funds for these, or yes, actually the way you posted, you can, right? And then we share that with the sub-grantees and say, here, we get that you were going to ask this, so we've already asked. It's not at us, but kind of the way you described it right now makes it sound more like it's a discretionary decision to stretch the dollars versus sort of a legal kind of disallowed use, per se, to use that term, which then raises bigger questions for me, which is, well, does that mean, you know, is the approach to how to distribute and prioritize the money as equitable as we thought, if we're trying to cover all geographies and say it'll shortchange what people get, but at least we can cover all geographies? So it does raise more questions for me, but I appreciate the transparency. I just wasn't clear if there was anything in writing that said, we are through our authority saying that is a disallowed use of the funding, but it sounds like they didn't say that. Yeah.
Correct. That's an excellent question and clarification. And I think that's accurate, that, you know, there is some discretion. It is a competitive grant. You will get proposals as a commission to score these as you feel appropriate, based within the restrictions of the parameters of the CARE Act. So I think that's absolutely correct. We did, as we mentioned, try to get clarification to the point that, Lauren is stressed, there's been communication, and the response was, the funding you have to work with is based on this and not this. But again, there is nothing that's specifically saying you cannot then look at a proposal that includes some of that and choose to decide that it is a strong bid and still meets the requirements. So I think that's accurate. And again, we're happy to go back for any further clarification, but that is
no,
correct.
I appreciate it, because what I hear is it says you could select it. It also doesn't mean that you'll disallow that use of funds if in the back end they say we did use it for that. So it's probably best to not get too deep into the RFP and leave it as general as possible.
I would say a competitive proposal would not leave the scoring team and commission wondering how the services that it's describing would be, for QLSP, would be representation in CIC proceeding or a matter related to a care agreement or plan, because that is like, unless that language changes in the in the Budget Act, like there should be like a pretty clear like it shouldn't take a huge leap to figure that out. So it should be, to the extent a proposal might want to take a kind of a broader reading of the quoted language in the slide. I think, just speaking personally, that's welcome. But it shouldn't, you would want the scoring team being like, I don't see how this is related to an underlying care agreement or plan or something, because that would be a tough proposal, I think, to approve.
Can we, Vanetta, go ahead.
Oh, thank you. Yeah, I appreciate all the comments. I think ultimately what we're talking about is continuity of care. And clearly the statute distinguishes between legal services and, behavioral, mental health, social services. Perhaps the goal of the QLSP will be to differentiate how they're going to promote these services, how they would advocate for these services, or how they would coordinate for the services. In other words, how will the legal aid provision facilitate the process if the grant is not going to fund specifically these providers? So I think it's a matter of scope of practice, but obviously it was established to meet all of these needs ideally, but implementing them is going to be a bigger challenge. So I think if the applications go out, providing some clarity to psychoeducation to the applicants about how they can frame that experience. That might be helpful.
Thank you, Vanetta. Catherine?
So just two thoughts quickly. And I appreciate what Vanetta just said. I think that's what we've all been talking about. I do agree with your restriction that says this can't be used for lobbying or auxiliary legal services, which are sort of those broader, like maybe grassroots organizing kinds of things that we've talked about. So that, just to be clear, I didn't have a concern about that. And in answer to the budget question, it seems like the funding formula in some ways is enhanced by the cost of a public defender providing services in those counties. Just noting that that calculation in and of itself, given what I know to be legal aid salaries, provides some room for flexibilities. And I imagine that in many of these cases, a lawyer will be working with a paralegal or a social worker to provide some of the other kinds of wraparound services or supports, to provide access to, not to provide the services, but provide access and advocacy to obtain those services. So I think I'm not really persuaded by the budget argument as the only answer to this. Just saying, I think there's ways that legal aid programs are used to being very creative about how they use their money to maximize it and be able to increase the access to these really important services.
Can I just clarify, Catherine, you what you said at the beginning, you're talking that the salary of public defenders will be higher than the typical legal aid lawyer. And so the budget differential between a public defender doing it versus legal aid is actually, that disparity is significant enough to actually have an impact as to
maybe not in every county, but certainly in a number of those counties, and that legal aid will be relying on workers or paralegals to provide some of the non-court representation. And that also provides some
I'm essentially jumping ahead, but it's like in the final column here is all the final column is doing is saying, if there's really 6 cases in Glenn and Glenn's allocation is 50,000, that provides 10,000 per case. So it's essentially, if a legal aid program were to say, like, actually, it would only cost us, $7,000 per case, and here's other work that is related to the care agreement or plan that we think is extremely important to maximizing positive outcomes for this care court respondent, we can do it within budget or something. I think that would be a very personally competitive proposal. Like, this would be my view of that.
I suspect the public defenders who do this every day are going to be far more efficient, so they'll probably do better, notwithstanding they're paid more.
We are at the 1 hour mark. This is actually the part of the RFP I thought the committee would want to dig into the most, so I'm so pleased that it did. And I don't feel like we're behind schedule or something, but because we have an hour left, we can, I want to hear what Lauren wants to say next, but then we can also circle back to this at the end before the resolution. But I might propose that we get through some of the other slides too.
And I'll just add, Chris, we can also make an edit to that specific piece where we do talk about that, the funding, if we want to further clarify, in order to get to a place where we do feel, it sounds like it's at least my take, that pretty clear on just kind of allowing a little bit more flexibility or discretion, and as opposed to like cannot fund, maybe should say, I don't know if like should, or if we want to kind of go further and switch that a bit to get to a place where that is an option too that we can do during this meeting before we get to the resolution.
Yeah, that's great. And I will pull up the RFP for when we do that. Just no one, Lauren, Christian, Rocio, don't let me forget that we want to do that. Hold me to it.
And thank you, Chris. I let you know earlier today, I have to hop off the call in just a minute. So I just wanted to make one last point before I have to go. Essentially agreeing with a lot of what has been said and what Rocio just said, that I think that line of what is enough of a nexus and what is not is still a little unclear. And in the interest of approving an RFP, if there's any way to fill in something about that, like the bar will evaluate whatever people propose, will provide technical assistance to figure out what's on which side of the line. I think that would be helpful. The only other thing I wanted to raise up is I can appreciate that you as staff and commissioners are kind of answering to two masters here, which I think is creating part of the problem. HHS has said very clearly, any nexus is fine. Any extra services for, helping people access things related to their care plan is fine, where you've got Department of Finance, who's just giving you this budget formula based on their estimates. And it seems as though staff is kind of going with what Department of Finance is saying, as opposed to the more flexible answer from HHS. And I'm just wondering if there's a way that you all can say, like, look, we're getting two different kinds of guidance here. And as a commission to responsibly administer this funding, we need one straight answer. Perhaps there's a way to get that answer.
Thank you, Lauren.
And I'll just add, I think we may be part of it. Maybe we seem to be, I think, maybe getting different answers from the same agency. So I think there's a bit of that we can go back and get clarification.
Thanks.
Okay. Well, so this question is not resolved. We can circle back on this, but I will just make sure we get through all the slides. So we left off on bullet point number 3. So before making awards to qualified legal services projects, the full commission must determine, this is in the budget bill, must determine an amount of funding. And sorry, I'll just say this where I feel like it's relevant. The commission has delegated authority to the committee to do this through the RFP. The commission must determine an amount of funding available to represent respondents in each county. Any funding not awarded to QLSPs to serve a county will go to its public defender instead. $20,400,000 to represent respondents assumes that a typical case will take about 40 hours. We have heard all along through the winter and spring that actually some counties think it will take more than that, but that is what the number is premised on. So staff recommends, and this is after extensive meetings with the Care Corp planning grantees, which are qualified legal services projects and support centers, with some of our agency partners, CalHHS, with the Department of Finance in particular. We recommend the following allocation method. The Department of Finance has provided very clear instructions on this first bullet, this first step, to allocate the funds by general population for at least this first year. The Department of Finance is anticipating collecting a lot of data from the 8 participating counties on how long cases actually take, and then to look back and see how many cases actually came up in each county and see if general population was a sensible allocation, a proxy for need allocation sort of method. But for this first year, until we have that real data, to allocate funds by general population, so that would be dividing each county's population by the total population of all 8 participating counties. You multiply that percentage by the funding available for QLSPs and public defenders represent respondents. So that yields an initial amount for each county. Then after meeting a lot with planning grantees, with representatives from particular counties, City and County of San Francisco in particular, was very helpful with step number 2 and 3. And the Department of Finance has voiced support for this, to set a funding floor if a county would receive, like Glenn or Tuolumne, if it would only receive, say, I think Glenn maybe would stand to receive like $15,000 or something. Set a funding floor that would allow it to meaningfully stand up this function in its public defender office, or for the QLSPs there to meaningfully stand up this project. So staff proposes a funding floor of $60,000. We looked at $125,000. We looked at $50,000. We looked at $75,000. Eventually, $60,000 was the sweet spot. That didn't result in some counties feeling they got way too little and others way too much. So any county that would be under 60,000 would come up to the funding floor of $60,000. The other counties would be adjusted proportionally. And then step 3 is where the math got a little bit more complicated, to layer on what we call a cost of providing counsel adjustment. To look, and so any county who is raised up to the funding floor would not participate in this adjustment. They already kind of got their bump. They wouldn't get a one on top of it. So essentially for those counties that were already above the floor, look at their public defender office, publicly available, updated every year, public defender office pay data for public defender's office attorneys and paralegals, and essentially look at each county's average pay and compare it to the 8-county average, and then layer on an adjustment. And what we really did is we kind of looked at the percent to which each county was above or below the 8-county cohort average, and multiply that by 10% of the pot for QLSPs and public defenders. So the next, go ahead, Judge Fine.
Where did you get the figure 40 hours a case?
That came to us from the Department of Finance, and I'm unsure where they got that from, but I know that a lot of counties were feeding data to them about what they thought, how long they thought cases would take.
Did
The
anyone
only,
ask me?
the only county that's actually affirmatively told us that they agree with 40 hours was LA County. Their estimate was super close to that.
They said 40 hours a
higher.
week. I mean, 40 hours a case.
For the whole case.
And Chris, do you remember?
I worked with them. I'm surprised they came up with that number. I'm very suspicious. Those guys weren't spending 40
some
hours a
counties
case.
have
Unless it went to
they think it
trial.
might be too little.
Too
Chris, do you
little?
remember the range? So I know that they gave a range and it shifted to the 40. I don't remember. Was it 20 to 40?
Oh, well, it started as 20 was the
Okay.
initial when it was
Just for context of, yeah.
6.1. Well, God, now I can't remember. It was $6.1 million was what was proposed back in January, and then it went up a little bit to something that I think looked more like 12 million, and that was back when the Department of Finance was predicting 20 hours per case.
Unless they're going to jury trial, they're not doing 40. I mean, I worked that court. They're not doing 40 hours a week. 40 hours a case.
My recollection is that it was supposed to be like an average, like a typical case would take 40 hours, and they thought some cases might be as little as 20, some would be 80, but like it would average out to about 40. No one's
Okay.
asking for my opinion or to editorialize. I do think that it's one of the things that all counties are supposed to report on in the first year is how long it actually took them. And then my understanding is next year's budget bill will reflect actual time spent in the previous year doing this work. And that if for some reason 40 hours turns out to be a huge underestimate for this year, there might be more funding available that can get injected midstream is what I have heard.
I would say overestimate.
So I'm going to just say if the estimate is 40 hours, and that's not what they're going to spend on the direct representation, great news, because it then supports that they can use some of that extra time to do the other kinds of accessing the other services that we spent a lot of time talking about before. So yet another reason why we should be more flexible with how the funds are spent.
Thank you, Catherine. Okay, so the next slide just has the breakdown. So
I'll just finish. That's one case per week. I mean, court time, 40 hours a week. And I can promise you the public defenders do a lot more than that in the LA courts. But anyway, all right. You've heard me. I don't want to talk much. It's just, yeah.
Thank you, I appreciate that. So here's the allocation for each county. So when looking at each county's share of the 8-county general population, Glenn would be under the funding floor, so they would be brought up to 60,000. Tuolumne was also just under, so it got brought up to 60,000. The governor's office is, like I reported earlier, is anticipating about 4,000 cases this year, and is anticipating that the breakdown between counties will be on the base, track to their general population. So the final column is simply taking the county allocation, dividing by the estimated number of cases to generate essentially technical assistance to public defenders' offices and then QLSP and support center applicants, QLSP applicants mostly, as to how much funding might end up being available per case if indeed there's this number of cases in each county. Essentially, it looks like Glenn is just getting a whole lot more than everyone else, but that is sort of the way of how the funding floor works. They are getting quite the boost. I do think that without the funding floor, they would be, I can't remember exactly what their allocation was going to be, but it was somewhere between like $10,000 and $15,000. It would not have been enough for them to meaningfully kind of build this into their public defender's office's work stream. Should the PD provide this representation? We heard no pushback from any of our conversations with the Department of Finance or county stakeholders or anyone about some of the smaller counties getting a floor. I will say, it occurs to me now that I didn't actually have a column showing the cost of council adjustment, but the cost of council adjustment didn't actually make a huge difference, except for San Francisco got a big boost. It's average public defender office pay for public defender, attorneys, and paralegals was quite a bit higher than the cohorts, the other 7 counties. Okay. So this would be the column number 2, the funding allocation would be the allocation that the committee would be approving in the RFP. Eventually, the full commission would be approving that when it makes awards. The third and fourth column is essentially just technical assistance to applicants. We don't know if that's actually going to be the real number of cases, but if it is, that's how the funding would break down for that county. It's kind of budgeting advice to help them figure out what's available. Okay. So the budget ceiling for qualified legal service projects, and this is actually in the budget bill, is essentially tied to the amount of funding available in each county for which they apply. So the budget bill says, the commission will decide how much each county is available in each county. QLSPs can apply for that, and essentially, if they want to apply for the whole pot of a county, that's their budget ceiling for that county. Support centers don't really have a functional budget ceiling in the budget bill. So staff has proposed a budget ceiling for support center applications of $500,000. Support centers, like they normally do, would be applying to serve 1 or more counties. We usually hope and expect that they'll serve more than 1 county, but that they will serve all 8 or some number of them. And they would just be applying for one amount of money to do that work. And they would say in their application which counties they'll serve and how much they need to do it. A budget ceiling of $500,000 would be enough for, or rather the amount for support centers would support 2 support centers getting the full amount, because it's $1,020,000 that's available to them. Yeah, Catherine.
So I'm sorry, I might have missed this, but is that amount set in statute, the $500,000 for a support center?
That's our office's proposal to the committee, is a budget for support centers, a budget ceiling of $500,000. The budget bill caps the amount for support centers as a full group at $1,020,000. So this budget ceiling, which the committee can totally choose a different number, would allow for 2 to get the full amount.
And how does that amount compare? I mean, some of the counties, with the exception of, I guess I'm just trying to understand the total amount of money that would be available to a smaller QLSP versus a support center, which seems a little inverse to me, but
like the support center would be getting too much. Is that what you're?
I'm kind of asking, I guess. I hadn't really focused on, I was thinking it was 500,000 for both of them. They each get 250 or something, but so what's the maximum?
So no, good question. Thank you. Yeah. So the budget, so the budget bill puts $1,020,000 sort of on the table for them. The committee can decide for the purposes of the application what the budget cap is, if any, for those applications. If it helps the committee to sort of think about it, we know some QLSPs are planning to apply. We have not heard any support centers say that they are planning to apply yet. Of course, we don't know if they will or not, but we're not expecting at this time a lot of support center applicants. So should one support center who's very qualified to provide technical assistance and trainings on the CARE Act want to apply for a $500,000 grant, I personally would be supportive of that if they were, had the infrastructure to manage that grant. But I could see how for 8 counties that might feel like a lot.
And Chris, correct me if I'm wrong, but if as you mentioned, if we don't anticipate any support centers, or if we get one, any amount not allocated or not awarded to a support center would go back into the pot for representation.
Yes, the budget bill, yes, does provide anything left over from the support centers has to go back to representation for respondents, which would be QLSPs and PDs that do that work. Okay, there would be no, and this is typical for Legal Services Trust Fund Commission awards. There would be no minimum amount that they have to ask for. So onto the scoring rubric and scoring criteria. So successful proposal, staff proposes to the committee that a successful proposal describe the applicant's ability, both its qualifications, but also its organizational capacity to provide the services it proposes in its application. So for QLSPs, we really just kind of pulled from the CARE Act here for the most part, but this list is in consultation with some of our agency partners. For QLSPs, the Judicial Council and CalHHS got to look at the RFP and weigh in as appropriate. For QLSPs, this would include experience serving adults who are experiencing a severe mental illness as defined in the CARE Act. Just experience working with that client community would be a relevant factor. Representing clients in mental health cases like LPS conservatorships or assisted outpatient treatment matters. It's my understanding that that existing work overlaps to a significant extent with this new work that the Care Court program is creating. So that would be relevant if they have experience doing that. Helping clients to access, and Eric, this is, I think, your point, helping clients to access the types of services and supports that the CARE Act seeks to provide. It enumerates particular services and supports that the QLSP in the public defender's office would be advocating for their client to receive or not receive in the care agreement or plan, like whatever their client's wishes are with respect to those enumerated supports. If the applicant has experience advocating for their clients to have access to behavioral health care, stabilization medication, and housing, that could be relevant. And then just generally experience litigating and negotiating, especially if it was with county behavioral health agencies, since they'll end up being the petitioners in the end. Yeah, Catherine.
So I think I think generally this is very helpful. I think it's a good rubric. I feel like we would be better served by using the language that's in the statute about what is a care agreement, what is a care plan, because it then answers that question that we've all been talking about, right? So appropriate range of community-based services and supports. We've already put housing here, as I think Efron noted before, but housing and other supportive services. Or supporting the respondent in accessing community-based services and support. So that language is in the statute. And so rather than just saying, for example, like using the statutory language seems like it would help programs understand what they're able to do consistent with the statute. And I'm gonna switch to a phone for a minute. I realize I'm gonna get a parking ticket if I don't go move my car.
Oh,
so
no.
I'll still listen in, and then I'll be back to this building and be back on Zoom. So sorry.
Thank you, Catherine. And I might circle back to you for this when you come back. Okay.
Sorry, do you want to ask a question now or?
Oh yeah, I was going to say, so I think in the RFP, and I can pull it up if that's helpful. Right, we do take the tack of like, the following might be relevant, and then it lists it. In the RFP, the scoring rubric actually avoids purposefully listing those specific things, and it kind of rolls them up. I don't know if this changes anything for you, Catherine. It rolls them up into what we call the qualifications row, which is just like demonstrates that it has the qualifications, knowledge, experience, relationships that it needs to accomplish proposed goals, and then we kind of kick it to the scoring team and the committee to decide when reviewing the proposals if they've established qualifications that fall below, meet, or exceed that scoring
So
team's
I guess
expectations.
where would the so on the slide before, where I was suggesting we expand it, so the scoring, a successful proposal would describe, and you have, is this going to be like guidance to the applicants about how to fill it out? Okay, so that's fine with me, that's fine. But then still adding those other parts in that are from the statute.
Great, and it would be guidance, but I would want to say we were envisioning having these also, they would be worded differently, but serve as application questions. So I don't know if that changes anything for you, but essentially just like, and we'd provide a space on the application where they could write about if they had experience with LPL's conservative or something.
Right, but I think it's
okay.
like, so this is going to say this includes experience, helping clients access the type of services, but that's the opportunity to talk about the breadth of services
That's right.
it could be providing under this. And then I think there's probably, just to Lauren's point, someplace we need to be clear about what services they can provide.
Great.
Would it be, sorry, Chris, not to, and maybe this isn't a good option, but if helpful, we can also pull up the RFP document that's in the meeting materials to walk through that to see how it's framed and like how it's meant to be guidance to the applicant in terms of when they're putting together their application.
Yeah, and I might just jump back and forth too, because this is a good time to actually just take a look at the RFP, and then I'll go back to the slides. Let me pull. Okay. Somewhat prepared for.
Are you talking about, Rocio, the section that says the application?
Yeah, on page 8 of the panel. Yeah.
So this is what the draft RFP. Oops, I'd originally highlighted a different section. So,
but is that grant parameters that you just pulled up to say have the same restrictions on it that are in what you had on that slide?
it's very similar. So
Well,
let
that
me.
would be a place to clarify.
So here's what it says. I'm sorry, the scrolling is a little obnoxious because Adobe doesn't like being zoomed in. Just ignore.
I think it was before that, maybe.
Well, there's a short section starting on page 8 about the grant, and then grant parameters is on page 14 of the packet.
I'm in attachment. Are we not in attachment A?
Yeah, we should be in attachment A, which is the actual. I found it. Proposed RFP. Okay, so grant parameter number 1, the proposed RFP says, this is Catherine, what you're asking about. This was on the slide. The one thing that is different here is we do say in the last sentence. Oh, so we do say it's a slightly longer sentence. So these grants are not to fund the wraparound services or supports, for example, housing, that become part of respondents' care agreements or plans. Additionally, lobbying and auxiliary legal services. I don't think this parenthetical was on the slide. For example, helping a client to apply for public benefits outside of their care process fall outside the scope of SB 101.
Yeah, so I think we have to clarify, from my perspective, we have to clarify that. So if you left it with matters related to care agreements and care plans, that seems clear to me. Because this is like inconsistent, right? You say these grants are not to fund the wraparound services and supports, e.g. housing, but later on you in fact say housing is okay. So like,
oh, so it's not, it won't pay the rent or the, what we're envisioning is it won't pay for your actual medicine, the prescription, or the rent, or the therapist.
Okay, that's fine.
Isn't the demarcation point that's relevant here the actual institution of the plan? In other words, you can work up to the creation of the plan, but then funding can't be used to execute on the plan.
Yeah. It pays for the representation.
Funding can be used to help you access the services in the plan. If this was just intended to say you can't fund the actual service, I think we all agree with that, but you can advocate to get the services. So maybe it's adding.
That is what we meant, I think.
Okay, well,
unless Rocio feels differently, that was what we envisioned.
How about nice and simple, but fund advocacy to obtain necessary services.
Yeah.
Yeah, it provided just as
it's
a global
really like
matter,
matters related to the
implementation
of the care agreements and care plans, right?
Yes, provided that it's in the proposal, it's a matter related to the care agreement or the care plan. So if it's, which is what we were kind of going for in the last sentence, if it's like not related to the their care process, it would fall outside the scope. So if it was
okay, but I think
so
maybe it's like two different paragraphs. So if you're going to say you like the part that's at least for my confusion was these grants are not to fund the wraparound services. Can we just make that its own paragraph? That seems like separate from, I don't know, to me it's clear if it's just its own thing. You can't use this for these funds. What you can't use it for, right? That's a separate thing, along with you can't use it for lobbying and auxiliary legal services, which kind of under the new rule has that's where it's also confusing to me, because I view that as you can't do grassroots organizing or something. But then you have this example of helping a client apply for benefits outside of their care process. Like maybe that last sentence belongs up, like you can use it for anything related to advocacy, care, matters related to the care agreement, including advocacy to obtain the services. You can't use it for services that are outside what's in the care plan or the care agreement. Isn't that what you're trying to say?
I think so. So the essentially the it was within staff's reading of the budget bill, the care proceedings, matters related to care agreements, care plans, that advocacy to it, the representing them in the care act, the care court proceeding, negotiating with county behavioral health to create the care agreement or plan, and then helping them to sort of like to enforce those care act rights to those things was all related to the care agreement or plan. Something that's just like does not exist as a services or support that the care act does not enumerate. It does not create a right for them to be able to access that into the care act, or it's just sort of like auxiliary in that, like, well, we spotted something else. I'm going to come up with like a really out there example, but like their child might have an individualized education plan need or something, but they spotted it. That would be unrelated to the care agreement or plan. And that's what that last sentence is supposed to kick off.
There's one other important part of progress is monitoring the progress. It's not just access, but also monitoring the progress, because you want to make sure the various institutions are following through on their obligations pursuant to the care agreement in court. That was another integral part of what we did in mental health court, is to ensure that the wraparound services are being provided. And also to see how the, I'll use the word patient, whatever the word is doing in the program. That's an essential part of these types of courts.
So I don't want Catherine to get a parking ticket, but since we
It's
still
not,
have you,
I'll take care of myself. I'll take the risk.
You're like, I'll take the ticket.
Was one of the suggestions then to starting with these grants are not for that to be a separate, so we say what it is funding and then what it's meant to not fund?
Yeah, just say not to fund the actual wraparound services. I like the word actual. I don't know.
So you would put the word actual before wraparound. I mean, yeah, we're happy to kind of wordsmith this to make this even more clear. But yeah, essentially what we're going for these grants are not to fund that sentence. It's just, it doesn't pay for the housing or the medication itself. You know, it doesn't, or the maybe behavioral health care at the time, the cost, that medical cost.
We're also, you know, I'm sure we'll be getting questions from applicants and providing TA to clarify any questions they get or that we receive from them to align with the direction the commission is going in terms of scoring the applications.
I mean,
That's
I
a
probably
great point,
still
Lucia.
have the, I don't know what this benefits outside of their care plan process means. So I don't know. That's kind of the Lauren question, I think, that she raised. There needs to be
Well, she
clarity.
said she
I mean, I
offered
think
an
it's in
example of like,
Go ahead,
Go
Chris.
ahead. I was going to say, I think we can create a hypothetical for a client that essentially has a care plan that has 4, 5, 6 bullet points, but the client has a 7th or an 8th. And the question is, what limitation does the money have if the client has additional needs beyond what the care plan enumerates?
Yeah, like
So,
welfare, right? Food stamps.
Yeah.
The one's a little tricky is getting Medi-Cal to cover some of the services.
and like food, CalFresh or food stamps is what we had in, not that particular benefit, but that's what we had in mind when we said helping a client apply for
No, I
public
mean,
benefits
the ones
outside
that are
their-
the easiest to understand are immigration and your child's special education needs, because the child is not part of the care. Like those examples, like I thought your point about immigration was fair, and the person's, you know, not going to do that, and they're not going to help your child with it. If finance use that example, like fine.
So,
Public
can I make
benefits
a word?
is too big to.
Can I make a word suggestion?
yes.
I think auxiliary is unclear.
Yeah.
I would say unrelated So if there are legal services unrelated to the care plan or that which fall outside the scope of the
That are
statute.
unrelated to the care agreement and the care plan. That seems the clearest, right? I
Yeah.
mean,
I like that.
Great. I am actually taking very detailed notes. So additionally, lobbying and legal services that are unrelated to the care agreement or plan, for example, helping a client to apply for immigration status, fall outside the scope of SB 101.
that I'm okay with the example if you need an example, that example. I'm
Or
fine.
no example, but it sounds like
Or no
an
example.
might be helpful, but it depends.
Yeah, I mean, I would just say to the extent that the immigration will always be outside of a care plan, that's okay to use. I have no objection to it.
Me neither.
I would hesitate to use any example that could conceivably be part of a care plan.
Yeah.
Because it will sow confusion, and maybe Judge Klein could sort of come up with one that will never be in there if immigration isn't work. But if immigration works, then let's just use that.
I think there's wisdom in that, Chris.
So I did capture this. So this is a change we can make. The
I mean, food stamps will be another one.
I can make an argument about food stamps, so I would use.
Well,
food
no,
stamps.
you
something
can,
very
but I don't
safe.
think that's related to the care, the premise of the care, which is mental health services. That's all.
Poverty and mental health, then there's a whole connection.
I know, I understand.
We don't have to debate it. Can we just leave it with immigration?
All right, yeah, that gets really,
The Christian's
really
point, there's something to be said about immigration being clean, and we don't have to.
Okay. So perfect. And then the reason I pulled up Rocio made the very helpful suggestion of pulling up the RFP is that we were originally going to look at. I got all that. So this is a change we'll make. The unless the committee changes its mind in the next 30 minutes. The other thing we wanted to look at, though, was how the rubric and scoring criteria are laid out. Let's see. So this is how the RFP approaches just describing things that might be relevant. So it's very similar to what's on the slide. So a successful proposal will persuasively describe the applicant's ability to perform the proposed work. For QLSPs, this includes, among other factors, the organization's experience. And then I paraphrase these bullet points on the slide, but the serving adults, I think the slide said serving adults that have severe mental health issues. I actually copy and pasted it from the CARE Act this time in the RFP. This is as it was presented on the slide, representing clients in mental health cases such as LPS conservatorships or assisted outpatient treatment matters. And then the other two bullet points, helping clients to access the types of community-based services. And what we're going for here is experience litigating or negotiating to get clients these sorts of things. To access the types of community-based services and supports that Welfare and Institutions Code Section 5982 describes. This includes behavioral health care, housing, and other services, and then litigating and negotiating. And then the rubric, as you saw on the slide, it doesn't list those things, but it contemplates a more holistic evaluation of their qualifications for this row. So Catherine, I think your point, Catherine may have stepped out, but Catherine's point, I think, was about this bullet point, listing out rather than maybe merely citing to the code, actually copying and pasting the list of enumerated services and supports. This section of the Welfare and Institutions Code is a little bit long. We can copy and paste pieces of it, but I want to say it's many provisions that are in this section, many subparagraphs. So I don't know, and Commissioner Blakemore will come back, but I don't know if anyone else had thoughts about this. Okay, if not, I'll move on, and when she comes back, we can circle back to it. I'm going to switch back to the slides. Or actually, you know what? I'll stay on the RFP because the next slide was just going to present the rubric, and I have it right here. So the rubric is based on the competitive, the rubrics we use for other competitive grants. We try and keep the structure the same across grants unless there's a a need to change it because it lends to predictability for applicants, and we have existing definitions for things like exceeds expectations and meets expectations, and it's just that infrastructure is already there for it. So we did that here. What is different about this rubric is the rows, the scoring criteria. We usually have a row like project impact and strategies. This essentially would measure, if this was a very competitive application process, it's where you could measure, like, well, this project is going to serve a lot of people and this one's not going to serve a lot of people. This one's going to do full scope representation. This one's only going to create Know Your Rights training materials or something. So for here, it's still relevant because you can look at how many respondents the QLSP proposes to serve in each county. You can look at, for support centers, how many counties they seek to serve, how much work they're going to do. Is it going to be, and usually the scoring team and committee takes into account the impact for the amount of money they're seeking. So if they're not seeking a lot of money, they can still get a meets or an exceeds. If it would still be a lot of impact for not a lot of buck, they can score high. But if it's a low impact and they're asking for a lot of money, they might score lower. So we kept this row. Qualifications is kind of where it's at for this grant. This is kind of the like, are they ready to do this work? It's going to be a very challenging client. Community in certain respects, the needs of the clients might be higher than what the organization typically sees. So have they worked with this client community before? Do they have experience sort of advocating for these types of community services supports they'll be negotiating in the care agreements and plans? Do they have experience litigating in court at all? That's where qualifications comes in. And then we usually have a project administration and a project evaluation as separate rows of the rubric. They usually get slightly fewer points. And historically, the commission has prioritized things like project impact and strategies and qualifications and the distribution of rubric points. So we kept that here. But these two, slightly fewer points for getting an exceeds or meets. Administration would look at their organizational capacity to do the work. So they might have lots of experience with this community or these areas of law or litigation, but like, do they have the administrative, IT, grants management, development infrastructure to make sure they're hitting their deliverables, they're tracking this grant, they're going to be reporting on time, grants compliance, there's safeguards for grant compliance and the like. So there would be an application question that would ask about this. And then project evaluation is this kind of a staple of the competitive rubrics. They would detail what their strategy would be to collect data midstream to kind of assess the project's effective, not just to meet statutory reporting requirements, but also to assess the effectiveness of the services and pivot as necessary to make sure that they're maximizing positive outcomes for clients. Usually our rubrics add up to 100 points, but because this grant doesn't really have the same sort of preferential features and opportunities like some of the other competitive grants do, like extra points for serving rural communities or extra points for serving underserved communities, which we sometimes have in the rubric. This is more like the court will for QLSPs simply me making appointments to you or not. This rubric adds up to 80 points. At this point, I will switch back to the slide deck if that's okay. Because we're close to the end of the presentation.
Chris, do we envision that QLSPs are going to be seeking to serve multiple counties?
For this first year, I am not envisioning that. I'm envisioning
That's a good
applications for specific counties. Yeah.
That's a good question, though.
Yeah, for this first cycle.
Okay. I mean, because I guess if they were, and maybe this is hypothetical, I don't need to worry about it, but if they were, would we have to then allocate their budget by the maximum for each county?
So if they apply to serve multiple counties, they will have to submit, the application is not released yet, but as designed, they would have to submit separate QLSPs, separate budgets for each county, how much funding they're seeking from that county's allocation and how they would spend it. And how it would be staffed in that county. Okay. So yeah. And I think for this first year, they probably will apply for one county, but they will have the opportunity to do more than one. So it is theoretically possible that they might submit a great budget for one county, but not a great one for another county. One budget that seems very sensible, and another one that has problems. And the scoring team could work with them, and the staff could work with them to try and make sure, to essentially make sure that both budgets are going to be okay. Yeah, Vanetta.
Hi, just a question about, they said the diagnostic criteria are schizophrenia or psychotic disorders. Do they indicate who's going to make that diagnosis?
Oh, I think the CARE Act does. I'm sorry, I don't know off the top of my head, but I think it does specify that. I'm so sorry if I get this wrong. I think it does specify that the county behavioral health agency will, as after the court determines that the petition establishes a prima facie case, there has to be an actual diagnosis.
Okay,
And
great.
within
Thank you.
14 days or something. Yeah. It is a rule. Yeah. Okay. So the staff recommends that a complete application look very similar to our other competitive applications as we design them, that include a project profile that would collect high-level information about the project, counties they're seeking to serve, total funding request, project abstract, and then a separate section that collects detail about their qualifications. We would have kind of application questions about that sort of example list of things that are relevant for qualifications, a question about organizational capacity to sort of manage and track the grant, a question about evaluation, a question about outreach, and we kind of pull from our question bank that we use for other applications. A project budget for QLSPs for each county they're applying in. And that would, like most competitive grant budgets we require, it would have to designate also sort of FTE staffing for that county. Budget narratives that explain each row of the budget. And then the State Bar always asks, or nearly always asks, for project assurances. It's a standard list of sort of assurances that we recycle each time. At the application stage, and among them are things we wouldn't, as far as I know today, do anything different for the CARE Court grant, but they essentially say things like, you acknowledge that your grant, your application is subject to Public Records Act requests. You acknowledge that you won't if you get this grant, you won't discriminate on the basis of, and then it cites state and federal anti-discrimination provisions. It's usually not very grant specific. They're more like global assurances. The reporting requirements. So I said at the beginning of the meeting that this is actually something staff is going to have to circle back to the committee on, and probably have a meeting just about this. So we're still figuring out with the Cal HHS, California Health and Human Services, Department of Healthcare Services, that also have, and Judicial Council, that also have reporting obligations under the CARE Act, what the reporting is going to need to look like for QLSPs, support centers, and public defenders. This is what we would recommend communicating in the RFP, and the RFP would say, like, this is essentially to be settled. Like, this is at this time, this is what you should expect. And we have some indication from the Department of Finance and others as to, like, it will probably incorporate these sorts of things in some form. Quarterly expenditure reports, quarterly services reports, possibly with client level data. So if anyone serves on the Homelessness Prevention Funds Committee, you know what this is referring to, but some grants require the grantees to report case outcomes, client demographics, like race, ethnicity, gender identity, disability status, at the case or at the outcome level. Like for this eviction prevention case, the client's race, ethnicity was this. Other grants, they can roll it up. They can just say X% of our clients identified their race and ethnicity in this way, Y% in this way. So at this point in time, to manage expectations, we propose that the RFP say possibly with client level data on the following, because it's possible that it'll get rolled up, but to be conservative and safe, we are sort of expecting it will be granular data. Client level data on legal outcomes. For the Legal Services Trust Fund Commission, we usually call those main and economic benefits. The verified, not verified status of those outcomes. This is something that homelessness prevention grants and the Cal HFA grants do require, verified but not verified. Level of service. So these are existing categories in the legal aid reporting handbook that we use. So, counsel and advice versus limited scope versus full scope. Demographic data, the commission usually collects race, ethnicity, gender identity, disability status, veteran status, limited English proficiency status, and active duty military status, and a couple of others. For QLSPs, we've already been told they'll need to report on how long it takes to represent respondents, how many hours, possibly some, I know we don't like the word auxiliary, but like related information, like how many hearings have they had, like per case. If for support centers, data about their technical assistance to QLSPs and other care court stakeholders like possibly county behavioral health agencies and whatever they're kind of funded to do. And then there might be the need for an annual, like a final or an annual evaluation. And of course, we always have a catch-all at the end of our lists of reporting requirements now that just says anything else that ends up being required by law. I do want to flag that when we come back to the committee with finalized reporting requirements, something that we are working on and trying to figure out is if we actually need to add some main benefit codes to the mix just for care court. Does the legal aid reporting handbook kind of lays out 109 or so legal outcome codes? Are those sufficient, or do we need to add some? And so we are deep in figuring that out.
Can I recommend that we don't do that until we actually hear back from the public defenders who are actually likely to provide many of the services? Because I'm not sure the guesswork is going to be useful.
So yeah, and what we're envisioning for like coming back to the committee to finalize reporting requirements is we're thinking mid to late August. So by then I'm envisioning that we will have had touch points with public defenders.
And if we do, just to add, one thing that we had discussed in the office is if we were to consider to add additional outcomes, that we definitely follow the similar process that we have in the past in convening some of our grantees and inviting potentially PD offices to join to come up with those together in terms of what would be potential good additions, so that we're not just guessing at what might be helpful.
So this was the resolution that was in the memo. So I'm gonna exit slideshow so I can edit it on the screen, but I'll reshare my screen in just a second. Did Catherine come back? Yep. Sorry, it's a little harder to, it's smaller now, but so let me edit it. So I actually took very detailed notes on how the grant parameters will look. And I just want to find a way to capture that in the resolution. Essentially, though, I'm going to say it out loud as a reminder. So it's kind of your opportunity to suggest a variation. Essentially, for that first paragraph under grant parameters, it would become 2 paragraphs. The first paragraph is just going to be the original first 2 sentences about what this funds. The second paragraph is the bottom 2 sentences about what's not funded, and it will read differently. I'm just going to read it out loud. These grants are not to fund the wraparound services or supports, for example, housing, that become part of respondents' care agreements or plans. Additionally, lobbying and legal services unrelated to matters, unrelated to care agreements and care plans. For example, helping a client to apply for immigration status fall outside of the scope of SB 101.
Yeah.
That was kind of where we ended. So that change is going to need to be reflected in this resolution. There's like 2 ways we can do it. I can either make this resolution very long by copying and pasting that into the slide, which is allowable, or I've seen this in the past. Rocio, if you have a preference. I've also seen if it would involve a lot of like copying and pasting, where the resolution becomes super long. We've also said as discussed at today's meeting, and it's documented in the recording.
Yeah, let's do that, Chris.
Okay. As
reflected in the amendments, just read into the record by you.
I want to say with the, And absolutely wordsmith me to your heart's desire. To the grant.
I would say
parameter
as
section.
reflected with the change. No, at the beginning, attachment A. As reflected, as changed.
As changed.
Or as edited.
As amended.
Yeah.
As amended,
By the committee during the meeting.
Do we need as reflected?
Maybe not, yeah, agreed. Man after my own heart there. Fewer. Less. Okay, we have a resolution on the screen. Anybody wish to move?
I will.
Thank you, Eric. Is there a second?
Second.
Thank you, Efrain. Okay, let's take roll.
My vote tally sheet. Okay, and did Catherine come back? My first one is Blakemore. So, okay, absent. Campbell.
You're on mute, Vanetta. And or frozen.
There we go.
There we go.
Yes, yes.
Vanetta. Iskin.
Yes.
Oh, I did. I skipped. I'm so sorry, Commissioner Escobedo. I skipped you. Escobedo.
Yes.
Thank you. Iskin. Judge Klein
Yes.
and Schreiber.
Yes.
Motion passes, motion carries. And that's our only resolution for today. We have
Okay, so we're
eight
gonna learn a
minutes to
lot.
spare. Yeah.
So we're gonna learn a lot in the next 6 weeks about interest and whether the money actually draws anyone out.
And I will say, and that's a good point, like just kind of got tie a bow on it. And with good feelings, the even if for some reason in this very first iteration, it's a modest number of QLSPs and sports centers that apply because it's only 8 counties, they want to wait and see what happens. Public defenders offices will be doing this work, and this funding, the county allocations are important. It's how much they're each going to get. They'll be reporting to the Legal Services Trust Fund Commission on the work they're doing. Like, this program is going ahead full steam, right? Regardless of how many QSPs or sports centers end up applying for this year. And the jury is still out on next year's interest when all 58 counties go. So, and I actually do think the interest could be a lot higher next year once the court program is up and running.
Can I raise a question of?
Oh, also Lauren came back. Hi, Lauren. Yeah, just
sort of not necessarily related, and I'm directed at you, Eric. One of the problems with conservatorships is a lot of people don't know how to fill out the forms. They're intimidated by it. And of course, Beth Sedek and Public Counsel had respective clinics on guardianship and conservatorship applications. I suggested to someone, and you're still on the committee at Beth Sedek, aren't you?
No, I'm not on the board anymore.
I thought you were on the executive council or something.
Yeah, well, okay, yeah.
All right. I but it didn't sound like they were interested, but I just think that's an important aspect that both legal public interest law firms served is that entry point into the system. I mean, how many people out there with the tragedy of having loved ones with severe mental health crisis, are following the whole notion of care courts. It may be the hospitals will direct them, but anyway, I'll just throw that out.
Yeah, Catherine, we voted.
I did. I was actually listening, but I was
okay.
I was in listen only mode or something. So
Yeah,
I was just going to see if I could record my vote in favor.
Yeah.
That was all.
That's,
Thank you so much. Good
yeah,
discussion.
yeah. Was it a yes?
Yes.
Okay.
Anyway, I'll just throw that out at
Yay.
the end of the meeting, something to think about, because I think it's kind of a weakness in the system if they don't know how to fill out the forms.
Thank you, Judge Klein. Yeah, thank you. I wanted to say a huge thank you for such a like robust discussion that I think the RFP is much better for that discussion. And thank you to Lauren for kind of catalyzing that discussion, and Commissioner Blakemore. Thank you to every committee member came today. This is like very inspiring. So unless there's any other questions or any other comments, that concludes staff's piece.
You need to get volunteers to score these.
Oh, yes, please respond to I think I gave everyone till tomorrow afternoon or something to like let me know if you're interested in scoring, and also your preference for the committee's next meeting and on August 1, 2, or 3. I think I've maybe heard from about half the committee members. So if you could let me know by tomorrow afternoon, we'd love to get that on the calendar. We do have at least 2 commissioners who have volunteered to serve on the scoring team. I think that the Legal Service Trust Fund Commission State Bar typically tries to do scoring in groups of no more than 2 commissioners, so that it can be more private, closed door type conversations. And so we'll eventually probably go for 2. So, but I haven't heard from everyone yet. So if you're interested, let me know by tomorrow.
This would be the one to volunteer for, because there may only be 2 applications.
Yes. Feel like you don't have to do
check
any
it
more.
off your list of
Homelessness prevention is like
responsibilities.
6 scoring sessions of 3 hours each or something, and this is going to be like 1 scoring session or 2 tops of like an hour to 2 each. That's
Do we think the lack of interest may be due to the controversy over establishing the court?
Yes.
I think it's also the Lauren, you might agree with this. We've talked about it, but the short time frame and delaying information to give grantees enough information to determine whether they have the capacity to build out staffing, to hire. We've all heard about the hiring challenges, to staff up to be able to roll out a new program. So again, why we're trying to expedite the process and give as much time as possible or notice of awards. And we'll see, we do anticipate more current grantees, current IELTS EAF grantees checking out the application than actually submitting one. So that'll be interesting too, to see how many folks just want to see what the application itself looks like versus actually being interested in submitting one.
Yeah, I will share down in LA, and that's I think partly why there was some push to do it earlier. Down in LA, I mean, I've been with the mayor here a couple of times, and she's mentioned specifically these grants a few times. So I'm pretty sure the mayor and the city are doing some pushing and encouraging some key organizations. It's part of her strategy and work that she's doing. So, at least in LA, hopefully we'll get some good applicants.
And Chris, I just
Okay.
want to say thank you for your thoughtful memo. I said that in what I sent you yesterday, but I thought you laid it out very nicely and clearly, and appreciate you taking the time to think through my comments. So thank you.
yeah, no, thank you. Absolutely. Great.
Thank you, Chris. Thanks, everybody. Appreciate it. And we will talk soon, and this will continue to unfold. So thanks, Chris.
Absolutely, my pleasure. Thank
Thank
you.
you.
Thank you, Christian.
Okay,
Thanks,
thanks,
all.
Rocio. Okay.
Bye.
Thank you.
JC.
Bye-bye.
Bye, everybody.
Bye.
Goodbye.